Hi everyone, and thank you for joining us today to Australian Business Lawyers and Advisors, a special webcast with Harry Dixon SC on managing workplace risks associated with COVID-19. Now, before we get underway, Harry and I would like to begin by acknowledging the traditional custodians of the land on which we gather and pay our respects to their elders past and present, and extend respect to Aboriginal and Torres Strait Islander people watching here today. Now, before we get underway, I thought I'd after welcoming everyone, probably introduce you to Harry Dixon. Harry is one of Australia's leading industrial relations senior counsel, and it's a pleasure to have him with us here today. His list of cases, if you look at the number of matters he's been involved in, it's either that industrial relations is either his passion or an unhealthy obsession. I'm not sure which of the two it is. And Harry, in an attempt to embarrass you perhaps a little, I was going to ask you how many decades you've been practicing in industrial relations law, if you might let us know, because I assume it's been for quite a significant period of time.
Well over 40 years.
Thanks, Harry. So, look, it's great to have Harry with us here today to navigate the myriad of issues that are arising. We've had a number of questions come through from our viewers already in relation to questions about the impact of COVID on workplaces, measures employers can take, and we're going to go through a number of issues that I think will address the questions that have been raised. Before I hand over to Harry, who's got some preliminary comments as well, I will say that we've gotten a lot of questions about whether employers can mandate vaccination. Let me assure you that's going to be something that we will come to towards the end, and Harry will certainly give us his views on that issue, which is obviously quite a hot topic at the moment. But with that introduction, I might hand over to Harry, who also has some introductory comments about the presentation we're going to give.
Thank you, Lewis. Good afternoon, everyone, and welcome to this session, which we hope you will find beneficial. As you would have observed from the first of our slides, this paper is not intended to be and should not be relied upon as the giving of legal advice. What Lewis and I wish to do is to raise for your consideration issues which need close attention and action in the context of the COVID epidemic, which is currently at large. As you will hear from us in due course, there is no one specific answer to all the various questions about what employers and employees should do or should not do in the context of the current epidemic. We'd also want you to bear in mind, not only today, but as you, as employers and potentially employees, go forward, bear in mind that in satisfying the rights and obligations which are both contractually imposed on employers and employees, but also under the statutory work health and safety provisions, you need to address this question not only in relation to the law, not only in relation to the factual position that pertains today or next week or 6 months' time. And the issue should also be considered as time goes on in relation to whether there are national health orders or state-imposed mandated orders in place, and how employers and employees will deal with their obligations post those restrictions being imposed. The position will not be one, in my view, when the government stop telling us as compliant members of society what we should and shouldn't do, that the employer and employees don't have an ongoing obligation to address the issues, which will, in my view, still remain very importantly to be addressed to avoid the consequences of the impact of the virus. In addition, consideration should be given, and probably earlier rather than later, as to how an employer and the employees will deal with their statutory and contractual obligations post a level of vaccination. For example, how will a workplace operate when there's approximately 80% of employees or members of the community, I should say, vaccinated, and a 20% portion of the community unvaccinated and potentially, therefore, more vulnerable? We're going to reach that situation, and I believe we'll reach that situation with restrictions or some restrictions being lifted, which may, in respect of the unvaccinated group, impose additional obligations or measures to handle the vulnerability of the unvaccinated employees in the workplace from contracting the virus. Now, having made those introductory remarks, Lewis has done some work and is about to run through briefly for you what we generally know about the virus, COVID-19, and various measures that may be available to counter the effects of those viruses.
Thanks, Harry. And the reason this is important is because when Harry comes to talk about the obligations that employers and employees have, the reality is all of those need to be viewed in the context of what it is that we know about the virus and vaccines and the impact of both of those matters. So we thought we'd just paint a brief picture about these things. The starting point's probably just to get the terminology right. There is actually a difference between the virus and the disease known as COVID-19. So coronavirus, or SARS-CoV-2, is a highly transmissible virus of the coronavirus family, and it's what transmits readily throughout society. That is to be distinguished from COVID-19, which is the disease that we as humans suffer when we're infected with SARS-CoV-2. And the disease that we suffer is the disease that has the symptoms associated with infection, whether that be coughing, whether that be more serious implications, right up to the most serious types of symptoms. As we know, there are a variety of variants of the virus already that have effectively developed over the last 18 months or 2 years. We've had alpha, beta, delta variants, and what we know is that the transmissibility of this virus has increased substantially through some of the variants. The delta variant, which is currently what we are experiencing in Australia, particularly New South Wales and Victoria and the ACT, is 100% more transmissible than the original virus and 40 to 60% more transmissible than the first variant that made its way through a lot of the UK. So we're dealing with something that is highly contagious, is probably the first point. The second element of that is that we know the transmissibility is through a variety of different measures. You'll see the variety of ways it can transmit over the phone, over the webcast there. You'll see it could be through respiratory droplets that pass by way of physical contact. It can be even through airborne particles. So it's highly transmissible, as well as the fact that it can circulate through asymptomatic carriers. Now, we don't know exactly how many people might carry the virus without knowing that they are infected, but the United States Centre for Disease Control estimates that approximately 30% of persons who are infected with the virus actually are carrying it without symptoms. The next thing that is very important to say, and this to some people might be obvious, but it's important to note because it really influences the comments that Harry is going to make later. This is an extremely dangerous disease. The mortality rate for confirmed cases is actually surprisingly very high. When I looked at the figures, you wouldn't necessarily pick this up from all our media reporting, but in Australia it's as high as 2.7%. So that is of confirmed COVID cases, the ABS is reporting 2.7% result in mortality. In the USA, it's 1.7%. In the UK, 2.1%. That's a very large number of people. It's, you know, in Australia, it's almost as close to 3 in 100 people infected. Or sorry, I should say with a confirmed infection. There are also a significant number of emerging long-term effects that we're starting to learn more and more about, colloquially being referred to as long COVID. These long-term effects can last for a couple of months, up to as long as 6 months or more. Some of them can be minor, others can be much more significant, to do with whether it's fatigue, and a problem referred to as brain fog, where people are having trouble concentrating, right up to the point that people who have organ failure will have ongoing problems. So it's not just the mortality rate we're talking about. There are ongoing serious side effects associated with contracting the disease. Probably the next thing that we want to talk about, once we establish that this is a highly transmissible, highly dangerous disease, is what role is played by vaccination. We know prominently of 2 vaccines mainly being used in Australia, the Pfizer vaccine and the AstraZeneca vaccine. Both are highly effective against the original strain of coronavirus. The Pfizer vaccine was 91% effective in preventing symptomatic disease. AstraZeneca, 82% effective, but most importantly, both were 100% effective in preventing hospitalisation. And those types of statistics are similar for the other vaccines that might be arriving in Australia shortly, such as the Moderna one. Now that effectiveness has dropped slightly in relation to the Delta variant of the virus, and particularly when it comes to whether someone develops COVID-19, both Pfizer and AstraZeneca have slightly lower effectiveness, but both remain 90% effective against hospitalisation. And so based on publicly available studies, it remains the case that someone who has a vaccine is much less likely to end up with serious illness than someone who does not have a vaccine, even with the Delta variant. The final question about some of the medical information, which is important to consider and where there is a little less concrete knowledge, relates to the transmissibility of SARS-CoV-2 and how that is impacted by vaccination. So we know it's a highly transmissible virus. What do vaccines do to that level of transmission? There's one excellent study on this in terms of actually directly answering the question and having a high level of response rate, and that is a Public Health England study pertaining to 500,000 households. And what they looked at were households where persons had contracted COVID-19, and they looked at the impacts on the balance of the household compared to whether the person was vaccinated or unvaccinated. And what they found was that in the unvaccinated households, the level of transmission was about 50% greater than in the person who contracted the disease and was vaccinated. So that's a pretty big piece of information that tends to demonstrate that vaccines are working to prevent transmission. However, unfortunately, that study was conducted before the Delta variant arrived in the UK. And so we don't know how those figures change in relation to the Delta variant. There was another study in the US that looked at the level of viral load on persons who'd contracted COVID-19. And again, those who were vaccinated had significantly lower viral load in their noses than those who weren't vaccinated. But again, that was a pre-Delta variant study. And so it seems that there's good evidence to suggest that for the other strains, vaccines do stop transmission quite effectively, or I shouldn't say stop, but impair or reduce the level of transmission. They don't pertain to Delta. We do know now anecdotally from certain countries that are well vaccinated, such as Israel, that vaccinated persons do seem to be having what they term as breakthrough infections and do seem to be transmitting at some level. However, there is still a level of consensus at the government level among medical professionals that vaccinations should slow transmission or reduce it to some extent. And that's probably borne out by two things that I draw attention to. One, the federal government's modelling, for what it's worth, assumes that vaccination will reduce transmission of the Delta variant by 65%. And secondly, the Australian Technical Advisory Group on Immunisation, also known as the TAGI, has issued the following statement. They say, in addition to strict public health measures, providing a first dose of COVID-19 vaccine will contribute to interrupting transmission in affected areas. ATAGI says that evidence suggests that a first dose reduces symptomatic infection and transmissibility, with the protective effect starting 2 to 3 weeks after vaccination. And so what we tend to be getting a level of expert consensus on is that the vaccines either should or do reduce transmission to a certain extent, and that's certainly the messaging coming from the federal and state government. But what we don't know is the extent of that. What's the exact percentage? What's the exact figure by which transmission is reduced? It just appears that there isn't information about that type of thing, particularly in relation to the Delta strain. So at a high level, that's what we effectively know about the virus, its transmissibility, and what vaccines do to impair its effects. And I suppose then we move to Harry. Well, what derives from that?
Thank you, Lewis. I want to, before dealing with the duties and obligations of employers and employees, just to draw attention to some of the mixed messages and erroneous messages which one sees coming from various represented members and also in the media. And you will see from the next slide some examples of this. This is an extract of some reports from the papers and media. The first extract from an employer who clearly seeks to want to have people vaccinated in his workplace. But he's looking at the regulators and legislators to allow him to operate his business in that fashion. Not paying particular attention to the obligations which exist already and permit businesses to achieve that particular result. Now, the next quote attributed to the Prime Minister seems, particularly from the reference to some state-based workplace health and safety laws, to diminish the effect of those laws, which apply with very serious consequences for breach. I won't touch on the next one because it's also not an accurate statement, but I want to go then to the next slide, on slide 13, and ask you to look at the quote from the website of Safe Work Australia, under the heading as to whether an employer can be liable if workers don't get vaccinated or required to get vaccinated. And it's quite an extraordinary statement, because it suggests that because there is insufficient evidence about the impacts of a vaccine on transmission, employees who are vaccinated could still attract COVID. And therefore, it is unlikely that you have breached the model laws simply because you don't require your workers to get vaccinated. It's an extraordinary statement because the very purpose of getting vaccinated is to avoid people from getting it and to avoid people from transmitting it. That message effectively is saying, why do we bother? Of course, the next statement attributable to a New South Wales Member of Parliament completely overlooks the fact that employees have duties and the freedoms and civil liberties of employees do not extend to the right to cause harm to others and perhaps cause death of others. And the last observations in the last two comments there really are just directed at the slowness at which rapid testing methods are being developed, although there's been some advance on that for the moment. So let's then look at the next set of circumstances. I want to just pose this question. An employee contracts COVID-19. It's established that the employee was infected in the workplace, and the employee, unfortunately and tragically, dies as a result of contracting the disease. Now, you've heard from Lewis as to the state of knowledge about the highly infectious and highly dangerous situation created by the virus. And if that employer 6 months later faces a claim for breach of its common law duty, or it is prosecuted for breach of its occupational health and safety laws, workplace safety laws, the position will be quite simple to start with. The position will be, well, employer, you knew it was infectious, you knew it could be lethal, you knew that there were measures and countermeasures available, and the question will be, what did you, as an employer, do to remove or minimize the risk of this dangerous virus being contracted in the workplace? You can't answer that question in the broad, absolute terms. One needs to look at the type of matters that are outlined in this slide 15, because it will very much depend on factors such as those set out in that email. In that slide. And in the absence of a careful analysis of matters like that, you're not going to get an easy answer as to what should or should not be done about all the measures that are available to counter the risk of employees and others contracting the virus. But I think it'll become a bit clearer as we go along, because what I want to do next is to concentrate very briefly on contractual obligations. And at common law, you will see that an employer has a duty to provide a safe workplace. As a result, an employer could be liable and exposed to claims for damages because the employer has failed to take reasonable care to ensure the safety of employees. That duty is to take reasonable care to provide a safe place of work and a duty to avoid the foreseeable risks. In the current environment, of course, those risks are very readily foreseeable. And so the duty extends to the employer's obligation to include a safe workplace in all areas into which an employee may reasonably be foreseen to be likely to go. For example, lunchrooms, toilets, public thoroughfares, and it's part of the employee's duty into other premises or other workplaces. Now, the employee's duties at common law are then also of relevance. The duty of an employee is to obey lawful and reasonable instructions or orders. One issue which arises is whether a direction given to an employee which extends to affecting an employee's private conduct is reasonable. Now, the answer to that question may well depend on whether such conduct has significant and adverse effects in the workplace because of its impact on other employees, or, and I want to emphasize this afternoon, or on the effective conduct of the employer's business. Now, pausing there for a moment, the effective conduct on the employer's business. If there is a conduct of an employee that, for example, results in a business being shut down for deep cleaning or because there's a cluster of employees who have contracted the virus, a requirement of common law to require perhaps vaccination or other measures to prevent that adverse impact on an employer's business may well be regarded as a reasonable order at common law, leaving aside, to which we will come in a moment, the occupational health and safety obligations by that employee. And I think in this regard, Lewis also wanted to add something.
Yes, because I agree, Harry. I think a lot of the discussion to date has been in relation to the work health and safety basis for issuing the directions that an employer might seek to make. But not only do things like having to shut down your business affect the employer and become something that the employer may be able to issue directions to prevent, but there's broader issues about consumer confidence. And I'd like to take a couple of examples. Take an airline, for instance. One of the big hurdles airlines are going to have to get over as they face 2022 is actually encouraging consumers or passengers to come back on board planes. And one of the things that the airlines will have to do is convince the public, the travelling public, that it is safe to travel with them. And so the airlines will have to do things like confirming that they have appropriate sanitisation processes in place. But a big step they can take to enhance consumer confidence is to say, we have a vaccinated workforce. And if they're able to make statements like that, they will actually have an ability to substantially encourage and improve the usage of their business by consumers. And creating public confidence, it doesn't just relate to airlines. It may well relate to personal services, whether it's hairdressers, nail salons. It may well relate even to hospitality businesses or restaurant businesses, where people are reluctant to go out. If there is a genuine connection between having a workforce vaccinated and establishing a high level of consumer confidence that enables people to come back to your business, that's going to be a substantial operational reason why the question about vaccinated or not will have a direct impact upon the employer's business. And I think that's another lens through which employers need to look at the question of vaccination.
Thank you. So let's then move on to workplace health and safety obligations. And the next slide, which is slide 19, will indicate the extent to which the various persons owe duties under the model laws and certainly the work health and safety laws in New South Wales, to which we pay particular attention. So the persons conducting a business, officers, the employees, or even other persons. And by looking then at the next slide, we've tried to summarize in tabular form some of the primary duties which are required to be satisfied.
Sorry, Harry, I'm just having an issue moving through, but keep going and I'll get the slide moving across. It's just slowed down for a moment.
That's fine. Well, let me make that's the slide that we wanted to pay attention to. Now, whilst you look at that slide, I want to make some general observations in respect of work health and safety. The first is that a breach of the duties that are outlined amounts to a criminal offence. Secondly, the duties are owed not only to the employees of the employer, but to others, such as contractors and persons on the premises of an employer. Thirdly, the workplace is broadly defined. We want to go back one. It is where work is carried out for a business or undertaking and includes any place where a worker goes or is likely to be while at work. So when an employer is devising policies for the safety of its employees, it needs to bear in mind, particularly in the current environment, that the employees may not be in the safe haven of their particular workplace, but it may be exposed to risk where they are required to go as part of their duties. Looking specifically at the slide, that slide, 20, you will see that the primary duty is shall ensure, as far as reasonably practicable. That obligation is strict liability, and ensure has been interpreted to mean guarantee, securing, or making certain. So the public debate that you see so far, or certainly that I've observed, fails completely to come to terms with the fact that employers have a duty to ensure, as far as reasonably practicable, the health of their employees in the workplace and other places. And the next point I want to make is that the duty is not concerned with the outcome. The duty is concerned with and based upon risk. So the mere exposure of persons to risks to their health or safety can give rise to the duty set out there, and that has been confirmed by the High Court in various recent dicta in decisions. Going then to, and just one last point to make as a general observation. The obligation, of course, does not only extend to the employees, but it extends to the others identified in the other table. But turning then to reasonably practicable point, I'm not going to dwell on this too much, but just running through the list, this is the statutory definition of matters that must be considered. The likely hazard or risk occurring to health. Well, in the current situation, it's pretty obvious. The degree of harm, pretty obvious. What was known reasonably ought to have been known about the hazard in the way of eliminating it. Well, that's not going to be too difficult in certain circumstances. And the availability of suitable ways of eliminating or minimizing the hazard of risk. There are various measures available, and we're going to come to that. And it's necessary to consider cost. Cost is a factor, but it does not mean that obligations and duties are to be satisfied without incurring costs. And that might well be a factor which employers have to bear in order to give effect to their statutory obligations. Turning then to the next slide, and you'll see that this obligation under Section 27 extends to persons who are conducting a business, or an officer of a business who has an obligation to exercise due diligence to ensure that the person conducting the business or undertaking complies with that duty or obligation. So an officer who's an employee has a duty to ensure that that employer carries out, by way of due diligence, the obligations. And bear in mind that the officer may be guilty of a criminal offence even if the corporation is not, or the employer itself, is not found guilty of the offence. It's a positive duty, proactive duty, and the consequences are very significant for individuals. The next slide deals with the obligations of workers under the Work Health and Safety Act. And you will see from that slide that employees or workers also have express obligations under the legislation. Particularly, you've got to take care about their own safety, but look at the third and the fourth columns, to comply with reasonable instruction and cooperate with any reasonable policy or procedure of the employer relating to health and safety at the workplace that has been notified to employees or workers. And worker is quite widely defined under the Act. There's also an ability of employees or workers to cease work if they are concerned about their own safety. The consequences of non-compliance with these obligations are serious. We've set out at slide 24 the very significant consequences. I'm not going to spend a great deal of time on that, but you'll see that there are various categories of offences. There's potential imprisonment for gross negligence or reckless disregard, and it extends heavy fines for corporations and individuals, which can have crippling effect on a business or individuals if not complied with. So that then brings us to some mitigating factors which we seek to illustrate by reference to the table at slide 26. And it's very important to start with risk assessment. The employers have a duty to assess the risk to the health and the measures available to eliminate or reduce the risk. Such measures then need to be tested by reference to whether they are reasonably practicable and whether it is reasonably practicable to apply them. But the starting point is one has to identify the risk, identify the measures which counter, either eliminate or reduce the risk, and then the test is whether it's reasonably practicable. One starts by reference to slide 26 to look first of all, for example, to the fact that there may not be one measure in itself which is adequate. It is almost certainly the case that a combination of measures may be required. And one measure may be required because another measure is either not practicable or is insufficient to satisfy the duty. Now, let's start with personal protective equipment. It's an absolutely obvious measure that's available. And I would doubt, though, that it is a measure, for example, masks, that would be sufficient on their own. And if the particular masks are not doing the right, are uncomfortable to wear, the employer may well have to find other kinds of masks that are effective and provide them as part of the PPE which needs to be provided. If one looks at social distancing, It may not be practicable in all cases. Employees may have to work in close proximity. It may mean more emphasis on other measures. And social distancing obviously has to be taken into account within the business where the employee usually works, or areas in which the employee may have to go to or have access to. Turning then to the question of testing. Devising methods of establishing whether an employee is vaccinated or not, so as to apply suitable measures consistent with the employee vaccinated status, may well be available to employers, in my view. And in this area, I draw from lessons learned from drug and alcohol testing regimes, which have now been in place in Australia for some time. In the 1990s, drug and alcohol testing regimes were introduced into various workplaces, initially with significant opposition from unions and employees, but gradually a greater acceptance. And the basis for such opposition was in part because it intruded into private lives and activities where drugs or alcohol were taken and they were not consumed at the workplace. Now, industrial tribunals throughout the country, however, supported testing based on the duty to provide a safe workplace. So, going back to one of the earlier cases in 1998, the West Australian Industrial Relations Commission said it is trite to say that the company has a duty to ensure, so far as reasonably possible, that it maintains a safe working environment, and it is reasonable for the company to take steps to put in place a scheme designed to detect, so far as possible, the level of consumption of drugs by employees and to implement procedures designed to deter the use of drugs in the workplace because of the potential impact on safety in the workplace. And as I will come to emphasize a little later, one can use the same reasoning in respect of testing and, in my view, vaccination as satisfying the requirements. In 2011, the Fair Work Commission recognized the right of an employer to test for drug and alcohol, and also made reference to an earlier case back in 2005 in Woolworths and Brown, where the full bench of that commission said, in the modern era, employers face an often bewildering array of statutory obligations in relation to matters such as health and safety, etc. Employers face potential liability arising from their common law duty of care to their employees and to members of the public. For these reasons, it's entirely reasonable and often necessary for employers to put in place policies with which employees must comply to facilitate the employer's compliance with its obligations and duties. And later cases, the Commission has recognized that risk to employee safety by drug and alcohol use has long been recognized, and compulsory testing, if necessary, if of itself, can be justified. So, bearing in mind also the question of testing, the question is what type of testing and rapid antigen testing. Obviously, in my view, this tool may be a very significant measure potentially available. Currently, it may not be reasonably practicable because of the unavailability of testing kits or government restrictions, but in my view, that change will come. And for example, 3 days ago, the New South Wales Health Department promoted the use and benefits of such rapid antigen testings, but it was with third-party providers to manage the process. And there's obviously a cost involved, but it is a factor which must be taken into account in satisfying the work health and safety obligations and contractual obligations. So in my view, in particular circumstances of the business, it can be shown to be a measure reasonably directed at ensuring the health of a particular employee or other employees or other persons, then employers have the right to test or require testing of employees, and the employees have a duty to cooperate. It will be necessary in those circumstances to have a clear and well understood protocol for such steps. And of course, it may well be an essential measure in due course if employees cannot be vaccinated, for example, because there are legitimate health reasons for not doing so. Now, there has also been some steps taken by employers as measures for employer contract tracing, which give rise to some privacy issues. And Lewis Izzo wants to make some comments and observations about privacy, particularly in relation to the general topics that we're talking about.
Yeah, thank you, Harry. The employer contact tracing is quite a creative approach being taken by some of the businesses that we're talking to. So what that essentially entails is employers setting up within their own premises a means by which they can assess where employees are at particular points in time so as to close down or confine areas of infection. Now, there's probably two ways that that's done. One is the well-known QR code method, which involves employers requiring employees to scan into particular buildings or sites. And what that gives the employer is a snapshot, if you like, of who was on a particular site at a particular point in time, provided employees do follow the process of taking the snapshot and entering the data. Then at that point, employers can use the contact tracing as a method of keeping their business open. If someone infected comes in, you can actually work out where they went and who they contacted with. The other method being used relies on other types of technology that were initially used, if you recall, in the COVID Safe app. So I do know some businesses are looking to use proximity type testing devices that effectively being a signal, electronic signal in a short circumference. And what that means is when employees move past each other or come into contact with each other, that gets registered. And the effect of that is that if there is an infected person on site, again, you're able to identify where they have been, and you don't necessarily have to shut down your whole business, but you can actually target your response at those that you know are in the greatest peril from a person being on site. So those types of methods are being used by some employers where they're able to invest in them, and that is another mitigation measure. And it's a mitigation measure in the sense that if someone does become infected, you're able to cast a net over the relevant exposed parts of the business. However, with a lot of these measures, whether it's testing, whether it's vaccinations, whether it's contact tracing, we do need to grapple with the Privacy Act at some level. The first thing I'll say is that the Privacy Act applies to most Australian businesses. It doesn't apply to businesses with a revenue of less than $3 million, but those businesses that exceed that revenue threshold, so businesses really other than small businesses, are subject to the provisions of the Privacy Act. The Privacy Act, very interestingly, has a specific focus when it comes to collection of records. It focuses on records that are kept in some way, shape or form by a business. So they have to be documented in some shape, whether that is kept on a register, kept on a piece of paper, kept on a hard drive. The Privacy Act does not regulate the mere citing of information. So to give a simple example, if a business needs to be satisfied that someone's over the age of 18 and cite someone's ID, but doesn't take any record of that matter, then the Privacy Act doesn't apply. But the moment you keep a record the Privacy Act kicks in. And why that's important is whenever you collect information for recording in any capability, in any fashion, there's a whole suite of things that need to be communicated at the point of collection. And just to give you a sense of what's involved, firstly, you need the person's consent if you're going to be collecting and recording information, but you also need to tell them the purpose for which you're collecting the information. You need to explain to them the consequences that will arise if they don't permit the information to be collected. You need to let them know what other entities will be receiving the information you've collected. You need to tell the person that you have a privacy policy that tells them about how they may access their personal information and correct it. You need to tell them how they can complain about any breaches of the privacy policy. And you also need to disclose whether the information will be going overseas at all. So you have to somehow grapple with those obligations. And if you are going to be collecting information as part of testing, seeking proof of vaccination or contact tracing, you're going to have a communication plan in place that ensures you satisfy your Privacy Act requirements. Otherwise, what you're trying to do, which may have very good intentions behind it, might be breaching a whole suite of other laws. And so once you've conducted this risk assessment process and you've looked at the measures that Harry's talking about, ultimately, you then need to revisit, well, how do I do this practically? And that's when you're going to have to consider Privacy Act consequences.
Thank you, Lewis. And then let me come to the question of vaccinations. Clearly, and current evidence, it points strongly to the fact that full vaccination provides protection to those persons. And if you look at statistics coming out this morning, 98 ICU cases in New South Wales are persons who are not vaccinated. Lewis has earlier identified the issues of transmissibility. So, in my view, given the current state of knowledge about the very serious adverse effects of contracting COVID-19, including death, it has to be, and in my view, is a measure available to employers to discharge the duties we have identified. A measure, and it may not be necessary in every case, but it must be a measure available to employers to discharge the duties we have identified. So in my view, if upon proper analysis, it is a measure which an employer concludes is necessary to address the risk, that employer has the right to require vaccination of particular employees in the workplace, and employees have a duty to comply. Remember, this is a duty, and the offence is based on risk, not outcome. But the question cannot be addressed in global terms. If you bear in mind what we outlined briefly in slide 15 about the different nature of different businesses and environment, you cannot address that question in isolation. It will also be necessary to consider whether other effective measures are available or necessary to eliminate or reduce the risk. And if there are other measures available, may not necessarily require the compliance with this request, but if they're not, then in my view, it would be a reasonable and lawful request of employees to comply with this obligation. But bear in mind, there is no one rule that fits all. Employees working from home, permanently working from home, are obviously in a very different situation from persons working in a close environment, in a commercial kitchen or in a commercial construction site where employees during their lunch breaks go and sit and eat lunch in a small confined area. You cannot address this issue in isolation of the particular circumstances of the employer and the particular environment in which the employees operate. It is, however, a measure which on current evidence reduces the risk of contracting the disease or of passing it on to others. And that is why we are all urged to get vaccinated. Requiring compliance is in those circumstances, in my view, in a particular case where there aren't measures available to otherwise reduce the risk, would be a lawful and reasonable instruction. One question that might come up is whether requiring employees to be vaccinated and cause harm to the employee may give rise to a separate liability on the part of the employer. That is a question which obviously has to be assessed separately on current knowledge and the likelihood of harm, of contracting adverse harm for being vaccinated against the adverse harm of contracting the virus. But I'm most concerned about the mixed messages that are coming out in this regard. And I cannot understand why employers are effectively being discouraged from mandating vaccination. To me, it makes no sense at all. And if one draws on experience on drug and alcohol testing and the purpose of that testing to ensure employees are fit for work and will not be exposed others to risk, vaccination is one way of establishing that employees are fit for working in a particular environment, therefore less likely to catch the virus themselves and less likely to transmit the virus to others. It seems to me that employers need to have the ability to require vaccination in a particular situation. And bear in mind that I'm not aware of many employers being prosecuted for imposing severe or strict safety measures. For those employees who erred on the side of greater measures, they are much more likely to be able to discharge the obligations than those who don't. I'm conscious of time, and so I just want to make a few observations in relation to requiring vaccination. First question is it reasonably practicable? Mostly yes, but two issues will need to be addressed at the particular time. One, the availability of vaccination clinics and doses. And secondly, in whose time this requirement must be fulfilled. The question will arise as to whether the employer has to make time available and will very much depend on the particular circumstances. The reasonableness of the requirement is more likely, in my view, if it is done in work time, if the employee chooses, and it may also be an incentive to help everyone get vaccinated. And it will also be necessary to deal with the temporary after effects of a particular vaccination. Now, there are a few other issues that we wish to address very briefly. If we look at the last slide, which is 27, I just want to say something in relation to policies and procedures. Clearly, it's advantageous to have a clear policy and procedure and protocol for whatever form of measures are put in place, particularly in relation to testing, vaccination, the wearing of protective gear, etc. It's important to develop those in consultation, but important to explain precisely what is required to employees and also to make clear the consequences of non-compliance. For example, there are cases, for example, in situations where flu vaccines have been vaccinated and employees have refused to undertake the vaccines, they've been dismissed because there's no work for them in the workplace, and the Tribunal, the Fair Work Commission, has upheld those dismissals on the basis that the requirement is reasonable, and in the absence of vaccination for flu, let alone COVID-19, employees, other people are put at risk. Make a proper record of all of those matters to ensure that if called upon, the employer can satisfy the duty or attempt to satisfy the duty available that is imposed on it. And it's not good enough simply to have a policy that's put in the file. There's a duty to maintain the safe and health policy and ensure that it's being complied with. In relation to the other matters on slide 27, Lewis has some observations in relation to the second to the fifth dot point, and I'll turn to him.
Thanks, Harry. I think the primary one that's most important to deal with pertains to discrimination laws. There will be some people who cannot be vaccinated, or it is unwise to be vaccinated because they suffer primarily probably from a medical condition, which means that they may be have adverse effects as a result of vaccination or it poses a serious risk to them. I think the starting point is to, rather than getting too excited about that issue, is to realise and recognise that those number of people will be quite small. Certainly in my experience, most people that have a level of immunocompromised systems, they're the ones being encouraged to go and get vaccinated early. And indeed, we've seen priority vaccination for lots of people with compromised health issues. But there will be a small number that are unable to be vaccinated for one reason or another. And it is entirely possible that requiring a person to be vaccinated may indirectly discriminate against them if they are incapable of being vaccinated, and that is because of a disability that they have, or potentially a religious belief as well can be protected by discrimination grounds. I genuinely think that the number of people affected by that will be small, and so employers should be looking to try and accommodate the needs of those people the best they can. It may well be that once you have a high level of vaccination in your workforce, that making an accommodation for a very small number that cannot get vaccinated for one reason or another is probably not going to impair your overall operational objectives. It might. And if it's the case that you're in a particular industry where you must have every person vaccinated, so be it. There are defences in the discrimination laws that talk about discrimination being permissible where it pertains to the inherent requirements of a role and reasonable accommodations cannot be made. And certainly you'd be getting advice at the time if you're looking at that scenario. But what I would urge employers to realise is that our advice today broadly pertains to the vast majority of employees. Yes, there will be a small number where you may need to look at a different approach. You might need to look at accommodating, whether it's a different way of working, whether it's different risk mitigation measures. There might be different things you can implement associated with testing, for instance, on a periodic basis instead of having vaccination. And you would look at those issues on a case-by-case basis when these rare instances arise. So that's probably the most important thing to point out. Briefly, you do need to bear in mind that the vast majority of the analysis today is based upon common law contractual concepts and the statutory work health and safety regime. You do have enterprise agreements in some businesses that may have their own requirements with respect to consultation about these types of matters. They may even have requirements to do with how an employer goes about implementing policies and procedures, or in some cases, whether you are even able to implement a new policy or procedure for a particular workforce where the EA is in term. And they're the types of scenarios where you will really need to look at your EA clauses before embarking on this course of action. So there's some kind of other ends you need to tie up practically before putting this regime into place. I think, broadly speaking, they're the main things I wanted to convey. There was one thing that Harry mentioned about this question about employers being liable if they require vaccination and if someone suffers an adverse event from vaccination. One of the things I would say about that, in addition to what Harry said, is a prudent measure to take is before requiring employees to undergo vaccination is also to have them obtain medical advice if necessary, if there are any concerns. So, for instance, they could get advice from a GP. If a medical practitioner advises them that because of a particular disability or illness they have, vaccination is not appropriate, then we enter back in that discrimination field. But it's not necessarily the case that employers would need to bear the whole brunt for this type of concern. If you are encouraging them to take medical advice before undergoing any procedure, that is an additional measure that means that before they undergo the vaccine, they've actually obtained separate professional expertise about the very act of vaccination, and that's something you might consider in the regime as well. So we'd aim to talk for about an hour, and we've gone through quite amount of detail. We had hoped to at least attack one or two questions, so we might just go for 1 or 2 more minutes. And Harry, I might pose one or two of the questions that we've received now. The first is, we've been asked, Harry, if it is a reasonable directive to enforce COVID tests on staff who are unvaccinated. Now, that's something you've kind of broadly covered, but what would be your response, a brief response to that type of concern?
Well, you cannot answer that question in isolation. You have to go through the analysis which we went through by reference to the slide about various measures that are available. And clearly, there are circumstances where it would not be a reasonable request for someone to be vaccinated because they may not come into contact with anyone else. And it may also depend on what other measures are available. But my view is, and you would have to consider the particular circumstances of the business, but in my view, there are circumstances where a requirement for vaccination is necessary in order to allow the employers to comply with their statutory and contractual obligations. And tied to that question, I think, was a further question as to whether it is reasonable for an employer to terminate the employment of an employee who refuses to be tested. One can't answer that question simply in isolation. It may depend very much on what other measures can be taken and how an employee reasonably could be accommodated. But the bottom line potentially is, if one draws on the cases that have been handed down by the Fair Work Commission in relation to employees in childcare facilities or aged care facilities who are required to be vaccinated for flu, and of course it will now be for COVID, and in respect of which there is no other place to work safely, it has been held that the employer has a valid reason for termination. But I would caution against answering that question just in broad terms. You would need particular advice on a particular day.
Thanks, Harry. One other question that arose was whether employers can compile a voluntary list of staff that has been vaccinated. And I think to that question, what I would say is, yes, you can compile that type of information, but you must remember that because you are creating a record of personal and sensitive health information pertaining to your employees, you're going to need to go through the Privacy Act regime. So you're going to need consent to obtain the information. You're going to need to inform people of all the matters I discussed earlier about why it's being collected, where the information is going to go, before compiling this list of vaccinated staff. And I think that's really important for employers to bear in mind, because I think a lot of employers will want to have registers of some kind of who is vaccinated. A final question for you, Harry, before we go. We've been asked if employers are looking at masks, and for instance, they implement a mask mandate inside, how do you handle issues that might arise from long-term usage? For instance, if people develop rashes and say they can't use the masks, then does that stop that being an available measure? Do you have any initial reactions to that type of issue?
Yes, thank you, Lewis. The question, as I read it on the chat coming through said, I know there is a mask mandate inside, but how do you handle issues like rashes, etc.? The first point I want to make about that question is the importance not to be relying simply on government mandating of what should or shouldn't be done. It is a real risk. Employers need to make that assessment individually by reference to their particular environment. And mandating mask is, in my view, an essential ingredient in preventing transmission of this disease. And when one goes around the limited areas that we're currently allowed to go, you will see, even in the limited venues that one can go, people hanging around not wearing masks, or coming into premises perhaps not wearing masks. So the first point is, employers can insist, in my view, on masks being worn, and should do so in certain circumstances. The question of whether the particular masks are uncomfortable or not takes one back to PPE obligations under the work and health and safety obligations. People have got to wear steel cap boots. They've got to wear hard hats, sometimes very uncomfortable. If they're particularly uncomfortable, the employer may have to provide an alternative. But the uncomfortableness does not entitle the individual employee to depart from that mandate. And if the employer does not maintain the safe work system, it will be liable. It may have to provide an alternative form of mask wearing, and the better the mask, the better the measure.
Thanks, Harry. Well, thank you everyone for joining us today. Thank you in particular to Harry for giving up his time to talk to our clients. ABLA will be actually circulating in the coming days a bit of a guide to some of these issues in the event that will hopefully complement the discussion you've heard here today, and we will ensure that everyone who has registered today will have access to that. But thanks again very much, Harry, and we're going to watch this space with interest. And thank you for giving us your time.
It's been a pleasure. Thank you, Lewis.